Good evening and welcome to the special presentation and discussion on courts and their effects on youth and young voters with Judge Deb Jacobson, brought to you by the League of Women Voters Rochester. My name is Anna Furling, President of LWV Rochester, and I will be moderating this evening's discussion. I want to thank LWV members for helping to organize this event. LWV is a volunteer organization active at the local, state, and national level to encourage citizens to vote and participate in government. I want to thank our youth civic engagement intern, Idra Clements. Idra is currently a sophomore at Century High School. She became interested in civic engagement while taking a government class as a freshman. She's especially interested in how youth can become more active in government. She heard about our program through school and is now participating as our youth intern. Judge Jacobson was asked to present on this topic by Idra because Idra has a strong interest in understanding youth rights in the court system, the protections that are in place now, how they have evolved, and how they may continue to evolve. I also want to give a shout out to one of our active members, April Horn. She has been mentoring Idra on several youth civic engagement projects this year. Thank you, April. And following the presentation, we will have time for questions. Please enter your questions through the Zoom chat box. LWV members will be monitoring questions and passing them on to me to ask during the last part of the program. We will try to get to as many questions as possible during the question portion. And just a few things on Zoom. Everybody's getting used to this, but this program is being recorded and will be made available via link on our website and Facebook page. You are welcome and encouraged to turn your cameras on. To avoid distractions, attendees' microphones will remain muted, and open the chat box to ask questions. Find additional information and links such as information on attending upcoming LWV Rochester events, volunteer to participate in our lobby and observer corps, voter registration, and candidate forums. They will be coming up this fall, again, elections. And while they're on there, you can join or renew your membership with LWV Rochester by checking on the join link and join us on our efforts to empower voters and defend democracy. Now on to our program. We are delighted to have Judge Deb Jacobson as our guest speaker this evening. I will ask Idra to do the introductions of our speaker, and I'll turn it over to Idra.
Thank you, Anna. We are delighted to have Judge Jacobson as our guest speaker this evening. Judge Jacobson is a retired senior judge from Rochester, Minnesota, and she worked for the court attorney's office from 1981 until she was appointed to the bench in 1993, where she served 23 years. Judge Jacobson has been retired 4 years, but still comes to work when the county needs her. Tonight, she will be sharing a little bit on her experiences in the court system and how it has grown to accommodate the special needs of youth, as well as an explanation of how judges are elected. Thank you. Judge Jacobson, the mic is yours.
All right, well, thank you. I certainly want to thank the League of Women Voters for inviting me. I do think I owe a special shout out though to Idra. I think it's just amazing here that a young high school student is not only interested in these topics, but takes on an internship, and April's been mentoring her. I talked with her a little bit about some of the concerns she had or what topics. So the topics that were selected really were Idra's interest in what she believes youth and juveniles would like to hear about in the court system. I see a few familiar faces. I don't have all of the galley up there, but I see Jane Callahan, so I see a familiar attorney face, and Karen McLaughlin, who can jump in as an expert here, having been an attorney in the county attorney's office and handling all those juvenile cases far after I left that office. So she can certainly chime in too. So the topics then are the ones selected by Idra or students, and hoping I can address those needs about the court system, and in particular juveniles in the court system. So truly the background, of course, of the court is that we're the third branch of government, that the judicial branch is independent of the legislative branch, independent of the executive branch. And of course, we've got the federal system, the federal US Supreme Court, those judges, but this talk really will concentrate and focus on the state of Minnesota court, and in particular, talking about our 3rd district and Olmsted County. So I just wanted to tell you first what the branch, the Minnesota judicial branch, has a vision. And these are all published, and there's a lot of information on websites out there, especially the ones on the Supreme Court, minnesotagov.com, I think it is. But the vision there is that the general public and those who use the court system will refer to it as accessible, fair, consistent, responsive, free of discrimination, independent, and well managed. And the mission is to provide justice through the system that assures equal access for the fair and timely resolution of cases and controversies. So just going back to a few basics about the court in Minnesota, there are the 3 levels also: the Minnesota Supreme Court, the Court of Appeals, and District Court. And the District Court is the trial court, the court of general jurisdiction, original jurisdiction. And we hear everything from small claims and conciliation court all the way up to murder in the 1st degree. And that's the court, of course, that hears witnesses, testimony, jury trials, motions. All the hearings are recorded. It's a court of record. There are 10 judicial districts in our state, and Olmsted County is in the 3rd judicial district. We're 11 counties, 24 judges, 1 family court referee, or what would be then like a magistrate to specialize in family court. And I'll read off the counties so I don't forget anybody: Olmsted, Winona, Wabasha, Houston, Fillmore, Mower, Freeborn, Steele, Waseca, Rice, and Dodge. In Olmsted County, there's 7 judges, and I thought since we're here with the League of Women Voters, I better let you all know there are 4 women and 1 woman referee, so that's pretty great. There are 296 district court judges in Minnesota, and cases in the 3rd, the best I could find was the report from 2020 that there were 53,544 cases. Now that's of everything from criminal, civil, family, and about 1997 of those were juvenile cases, but that would be in the whole district. The next level of court then was the Court of Appeals, and that has 19 judges. They hear over 2,000 cases every year, and they review the final decisions of the trial court. So if a party disagrees with the trial court ruling or a jury verdict, that party files an appeal, and they submit written documents, written briefs, and sometimes oral arguments. So that court isn't hearing like the trials and jury trials. They're just reviewing the matter on paper and oral arguments. That court began in 1983. So the top court, of course, is the Minnesota Supreme Court, and there's 7 justices on the Supreme Court, led by our Chief Justice Lori Gilday. And again, out of the 7, there are 4 women on the Minnesota Supreme Court. They are the final arbitrator of the constitutional rights of the people of our state. And if a party disagrees with the Court of Appeals, they submit a petition for review. And our Supreme Court accepts about 1 out of 10 petitions. So about 75 petitions are heard each year, but they also hear direct appeals from 1st-degree murder convictions. I did, looking at the website for Minnesota Judiciary, they have all kinds of demographics, but they don't have women. So I had to, email somebody, and they got back to me. Our presence in the court system, there are 52.66% of women judges in the state of Minnesota. And our first woman on the Supreme Court was Justice Rosalie Wall. She was appointed in 1977, and she was on our court until 1994. She died when she was 89 years old in 2013. And if others are interested in her biography, I think they've done a movie too, but her book was The Girl from Birch Creek. She had a pretty fascinating life and was a leader for a lot of us. Selection of judges in Minnesota was also a topic the students were interested in. And judges in Minnesota are elected to a term of 6 years in the general election. There are vacancies between general elections, and they're filled by the appointment of the governor. And that's from a list of Commission on Judicial Standards. But after an appointment, a judge has to run in the first general election after that appointment. Now, our judges here in Minnesota, pursuant to our Constitution, are elected in that manner after an appointment and elected every 6 years. Unlike federal judges that, pursuant to Article 3 of the US Constitution, have lifetime appointments as long as, I guess, good behavior is what I read. Those appointments, and everybody's probably now watching what the president will do in terms of a nomination for the US Supreme Court, and of course the confirmation hearings by the Senate, but that's a whole different process than Minnesota. My personal background is I'm from Owatonna, Minnesota. I grew up there. I graduated in journalism from the University of Minnesota. I went and graduated then from William Mitchell Law School in St. Paul. Now, back when I went to school, it was a night school. So it took 4 years rather than 3. That law school now is mostly days, as I understand it. And now it's Mitchell Hamlin in St. Paul. It combined with Hamlin Law School. I was a law clerk for about a year with the 3 family court referees in Ramsey County, St. Paul, and then a law clerk for a district court, Judge David Marsden in Ramsey County for almost 2 years. And then I was fortunate enough to get a job as an assistant county attorney in Olmsted County. That's back in the day where there were 4 attorneys in that office, and I have no idea how many there are now, but more than, I don't know, 3 times that for all I know. So it was a different world back then. And how I ended up even being here tonight was my former boss, Ray Schmitz, gave me a call and said the league was looking for a speaker. So Olmsted County was really good to me. I learned a lot. I liked it. It just gave me a lot of experience and support. When Judge Roger Plunkett retired, then you fill out an application and get letters of support, and then you're interviewed by the Commission on Merit Selection, and they make the selection and narrow down the candidates. The year I was there, they narrowed it down to 4, and then we're interviewed, and I was appointed by Governor Arne Carlson in 1993. In October of 2017, I retired, and now I'm on that senior judge status, and where you keep up your continuing legal education credits and fill in as needed. And frankly, I never thought there would be a lot of opportunity for that other than maybe filling in if somebody's sick. But because of the pandemic, senior judges have been in a lot of demand because the districts are quite behind trying to catch up. And so I think at our last judges conference in the fall, the statistic I heard is that the senior judges in the last year have filled in to the extent of 13 full-time judges. So there's really a way to try and catch up, and it's been interesting. When I started in 1993, there were 2 other women judges in the district, Judge Ancy Morse, who was the first judge out of the metro area appointed to the bench, and Margaret Johnson was in Winona County. They're both now retired as well. In the district, our 3rd district, there are 24 judges. 1 will be retiring in Albert Lee, and there's already a candidate that's been selected by the governor. And I think then we either have 13 or 14 women now in the district as judges. So Idra and others wanted to know about juvenile court and how it's separate from the adult court. And the jurisdiction for the juvenile court then is for children less than 18 years of age. And so how does a juvenile come into the court system? Well, there's a variety of ways. The most common one that people think about, of course, is delinquency, and that's like criminal court. Other ways are traffic. You could come in as a victim of a crime. You could come in through child protection, or our favorite, of course, and fun one is adoption. The adult criminal and delinquency rules really are quite similar. They both require proof beyond a reasonable doubt. It's an adversary system with prosecution for the state represented by the county attorney's office, which you'll find is pivotal in almost all of these actions with juveniles. So they prosecute for the state, for the people of the state. and how that crime might be investigated. Let's say it's a burglary or a robbery. The police would investigate. They may or may not arrest. There's hearings in both the adult or juvenile systems, trials, sentencing. But the county attorney is the one that makes the decision whether to charge after reviewing police reports and to either file a complaint in adult court or petitions in delinquency court. So while there's a lot of parallel kinds of hearings and rights, the names of the hearings are a little bit different. In juvenile court, the real difference from adult court is the court and society is looking for rehabilitation rather than simply punishment or deterrence. While those are important, rehabilitation is the key. And our statute has sets forth that whole concept about the unique characteristics of children and looking at their best interests. And I'll just read a little bit of that statute. The purpose is to promote public safety, which obviously is still critical, and reduce delinquency by maintaining the integrity of the substantive law prohibiting certain behavior and develop individual responsibility for lawful behavior. This purpose should be pursued through the means that are fair and just and recognize the unique characteristic of children and give children access to opportunities for personal and social growth. The students also wanted to know about the right to counsel, and that's been incorporated into our rules for a long time. The right attaches at the first appearance for gross misdemeanors or felonies, so serious matters. And you would have that attorney from the very first hearing through trial through sentencing. But going over a little bit of that history about the right to counsel, I thought I'd at least bring up the two US Supreme Court cases that started that whole process. And for students to know that that's been around since the 60s, 1960s. First, those rights had to be extended to adults in Gideon versus Wainwright way back in 1963. And Gideon was an adult with an 8th grade education, kind of a drifter in and out of jail. He was charged with felony breaking and entering, and he asked the judge in Florida for a court-appointed lawyer because he could not afford one. Well, at that time in Florida, the only way that a defendant could get an attorney for free or to help him out was if he was facing the death penalty. So the judge denied that. Gideon went to trial, he was convicted, and he appealed. And in a unanimous decision, which overruled some other cases, the court found that the guarantee of counsel is fundamental to a fundamental right, and it's essential to a fair trial. So they extended the right to the states and to adults. So a few years after that, in 1967, the main case for students to know about in juvenile representation is in Ray Galt. And Jerry Galt was a 15-year-old accused of making obscene phone calls to his neighbor. He was also on probation for theft, and he was arrested and placed in detention. And this was in Arizona that certainly at that time must have had a lot of procedural problems because no notice was given to a parent about the arrest. No one saw the complaint for a couple of months. There wasn't a transcript of the proceedings. And yet he was sentenced to 6 years in jail. And there was no appeal in Arizona. Somehow it got to the US Supreme Court, though, and again, a unanimous decision, and finding that due process is primary and indispensable for the foundation of individual freedom. And they noted that had Galt been 18 years old at the time of his arrest rather than 15, he would have been afforded this protection. So while they also noted that there were legitimate reasons for treating juveniles and adults differently, juveniles facing delinquency and incarceration are entitled to these same procedural safeguards. So those Minnesota adopted those rules and the right of the counsel right at the first appearance in court. And our state now has a public defender system, and the state began funding that in about 1989. There's 560 public defenders now in Minnesota. And so if you came into the courtroom, if you were the burglar or the robber alleged at the time, the first time you got to court, your public defender would be with you. So the difference is a little bit, or just going over some of those hearings, you might be in custody as a defendant or a juvenile, and you'd have a hearing, and in juvenile court, you'd be looking at out-of-home placement or going home. As an adult, you'd be thinking about bail or releases. The hearings in adult court are open. They're to the public. The juveniles, if you're under the age of 16, those typically are closed. 16 and above, they can be open with felonies. If there's out-of-home placement, unlike adult court, the juvenile court continues to review placements. Sometimes it's on paper, sometimes it's in court, but at least somebody doesn't get lost in the system. There would be pleas, settlement conferences. Trial is a bit different. The court has jurisdiction until age 19, typically, other than some other, it's called extended juvenile jurisdiction or certification as an adult would change things. But the typical delinquency petition is till age 19. The trials are to a judge. In the adult court, the defendant has a right to a trial by jury. And there was a case in 1971, McKeever versus Pennsylvania, that still found that there were unique circumstances to not allow jury trials or give that right to juveniles. There's sentencing hearings or dispositions in juvenile court, but again, looking at best interests of children and rehabilitation. The question that I think some of the juveniles had were, who does the court listen to at these hearings? Well, if it's obviously a serious crime, like let's say a burglary, a robbery, sexual assault, the court would first have to determine if the juvenile should be held in detention, maybe a jail, a mental health facility, or go home with some conditions. And at that hearing would be the county attorney, probation or court services, parents, the child, and the child's attorney. So the court has to listen to all those folks and make a decision. What's also helpful, though, is probation usually supplies a report, having met with the family, or maybe they knew the child before, and gives some recommendations about what's going on for that child, or do we need more evaluations. The presumption, though, in terms of out-of-home placement is the child should be going home unless, and the court would have to find, the child would endanger himself or others, would not appear for court, would not remain under the care, custody, or control of a parent, or the child's health or welfare would immediately be endangered. And there's some other factors that the court would think about in terms of, is this a presumptive prison sentence if it was an adult? Is this a new felony while another one is pending? What's happened with past out-of-home placement? Did the juvenile escape from custody or willfully not return for other hearings? And while those words are a little bit different, it is similar to what a court thinks about with adult matters in bail hearings, looking at the nature of the offense, the weight of the evidence, family ties, employment, character, length of ties to the community, the history of appearing in court, victim safety, safety of others, community safety. The only difference after the trial, if there's trials, the trial to the court, there could be pleas and the sentencing. And again, those are public if someone's over the age of 16. The sentencings are usually dealt with by having what's called a predispositional report. And again, court services makes inquiry into the matter and makes other recommendations. So that's one other voice with the child, the parent, the county attorney. So those are kind of the more serious matters, how they're dealt with. A juvenile might come into court, though, with a petty offense, and those would include curfew, alcohol possession, small amounts of marijuana. And then, of course, there's some smaller misdemeanors, typically, I guess you'd say shoplifting, theft, those kinds of level of crimes. And here they're dealt with, you would not be placed outside of your home. You're looking at treatment options or fines or community work service. But the county has a diversion program that would allow a juvenile with a contract not to come to court, admit the offense, and after that, probably do community work service, follow through with whatever the contract required. And there's been then less recidivism, it's quicker. And frankly, a lot of those kids never come back to court. It's a mistake somebody made, but enough that it had to be charged out. The other way a juvenile can come into the court system is as a victim of a crime. And as a victim of a crime, there's a whole statute about that, 611A, that you can be notified of the right to request restitution for a violent crime. You can ask that a public access, that your address and name not be given out, that you can participate in the victim assistance programs in the state, and Olmsted County clearly has a good victim witness program to assist victims. The victim has a right to participate if the offender is charged and know what's going on with the prosecution. Before a plea agreement, the prosecution needs to make good faith efforts to notify the victim of the terms or what the sentence recommendation is. A victim has a right to be present and to object to a plea agreement. The court then has to take that into consideration whether to accept the plea or not. The victim has a right to be present at sentencing and present what's called a victim impact statement, either in writing or orally, or have someone read it to the court. If there's a trial or during these other hearings, the victim has a right to have a separate area from the defendant, or at least be kind of guarded, if you will, to not run into the defendant or the defendant's family or witnesses. When probation decides or knows they need to make recommendations to the court about sentencing either adult or juvenile for serious matters, they do need to make a good faith effort to reach a victim to see if the victim wants to have input with the court. And of course, the victim can also request certain damages from the court that the defendant would need to pay. Also, juveniles could come into the court system under child protection. Now, this is a civil process, not criminal. Nobody's going to jail, but it's how the court system helps abused and neglected children. And the court, along with social services, needs to provide for kids safety, well-being, and permanency. And permanency is one of those big topics that prompted some reform, I guess, in the last 20 years. So there's examples of abuse or trauma that are addressed in child protection cases. Physical abuse, sexual abuse, parents that suffer from chemical dependency or mental illness, chronic neglect of kids. This is where you think of kids with bruises, broken bones, babies born to a mother that's drug addicted, sexual abuse of children. That's the nature of how serious those cases are that come into the system. And that process, again, is there are reports to social services for investigation, reports to law enforcement. And most of those reports really do come from mandatory reporters. And those are those professional people who know or have reason to believe that a child is being neglected or physically or sexually abused or has been neglected within the past 3 years. And that individual needs to report that immediately to the welfare department, social services, or law enforcement. And there's quite a long list of those folks that are in mandatory reporting categories. Those that are a professional engaged in healing arts, social services, hospital administration, psychiatric treatment, childcare, education, correctional supervision, probation, law enforcement, or clergy while in their ministerial duties. So once that report comes in, social services needs to make a decision about how to address this report. And sometimes they're able to work with the family and refer for services or provide services. And the idea is address that problem if it's true and keep a family together working on those issues. But when families are unable or unwilling to engage in services and make those changes to keep kids together without risk of harm, that's where that court involvement comes from. So again, the county attorney represents social services. It files what's called a CHIPS petition, Children in Need of Protection or Services. And there's a list of actual, the statutes that apply here. And you can imagine what these might be in terms of a child's been abandoned, or a victim of physical or sexual abuse, or resides with a perpetrator of abuse, who's without necessary food, clothing, shelter, or education because a parent's physical or mental health is unable or unwilling to provide that care, or without a child who's without special care necessary for physical, mental, or emotional conditions. If a child's medically neglected. The one that's often used is a child that's without proper parental care because of the emotional, mental, or physical disability or state of immaturity of the child's parent, guardian, or other custodian. There's also failure to thrive children, sexually exploited youth. If this would be fairly rare in our county, but if a child committed a delinquent act before age 10, is a runaway, or a habitual truant. And it's been a while since I've seen truancy petitions, but that's a whole separate area, really, with a special programs, working with the school. And finally, if nothing has worked to get kids not to be truant, then they come to court, and social services tries to work with them in a little more meaningful or structured way. The hearings involve wanting safety. Sometimes the kids have already been placed voluntarily in foster care. And at that first hearing, the decision needs to be made. Usually by this time, it's pretty severe in Olmsted County. Kids are either out of home placement or have asked the court even in an emergency hearing to place the kids out of the home. The other cases, they're trying to work with voluntarily. But at that hearings, the county attorney, the social worker, parents, and counsel for parents, and parents have a right to have counsel and court-appointed counsel. Older children are notified if they want to appear. Efforts need to be made to find out if anyone has Native American heritage, because a tribe can intervene. And if things really don't work out here, the finality is kids either go back home and they'll be safe, or there's a termination of parental rights. So these are really serious matters where kids can lose parents, parents lose kids. But again, what the juveniles were interested in was who's at this hearing? Is anyone there for kids? There is a separate voice for children, and that's the Guardian Ad Litem, the Guardian Ad Litem program, and they represent and make sure that we're addressing best interests of children. Now, everybody's on board that that's what we want to do, but they act just for the juvenile. They meet with the kids, they can meet teachers, others, read reports, they file reports. Now, this program that we had in Olmsted County started in the early 1980s. And then it was volunteers and volunteers under social services. Then it moved to the court system and then to the district, really to make sure it was more independent of social services. And now it's under a statewide program that's mostly employees, but well-trained employees to look out for best interests, full-time, part-time, in a few areas still use some volunteers. The hearings obviously are really very serious issues. And the goal, no matter how serious, is still this reunification with parents and having a case plan that they know what they have to do. What are those expectations? Do they need to get to some kind of treatment? Do they not have to use drugs anymore? Do they need to see a psychiatrist? How can they meet the needs of their children? And sadly, a lot of these kids have huge needs as well. They need some safety, treatment, and just some daily security. The goal still is with that case plan, but what changed in the last number of years really was a timeline. In the old days, we'd have a review and a review and a review, and it went on and on. You didn't know what we ended with. Kids remained in foster care for a very long time. Now, children under the age of 8, 6 months is the time frame. Now, a court can continue that and if there's progress, if a child's over the age of 8 at 12 months, to work a case plan and to change those conditions that led to the risk in the out-of-home placement. And those services need to be reasonable, offering services of counseling and treatment. Excuse me. What happens though when parents don't meet those goals, whether it's 6 months or 12 or whatever date that everyone thinks is reasonable? You don't want kids in foster care forever. And so social services really, even at the beginning of a case, has a backup plan, if you will. Where should these kids be placed? And so they really look hard for relatives, even out of town or out of state relatives. Certainly foster care plays a huge role in meeting the needs of these children. But the idea is to find them a permanent family and something that's more permanent than wondering where they're going to be in their lives. And how a lot of this got started really was the Children's Justice Initiative. And it began in 2000 and is now truly incorporated into the whole process and the expectation of the court, social services, and providers. And the purpose back then was to improve the whole processing of child protection cases and outcomes for abused and neglected kids. And the phrase back then, and I think it still is important, is when we looked at the process was through the eyes of the child. And it was important. That's why those timelines, because time for kids is a whole lot different than, somebody that's retired, where the time just zips by. But those kids are, they're waiting and waiting. And the example always was kids waiting for Christmas, kids waiting for summer, those kinds of what they're waiting for. So there was a collaboration with the judicial branch and the human services branch, and there were teams in every county that included a judge, decision makers for social services, the county attorney, counsel for parents, the public defender, guardian ad litem, treatment providers, court administrator, and meeting frequently. And in the 80s, even case law, there was a shift from court procedures, but also that considered way back when just the rights of parents and sort of let the rights of kids go. And in about the 1980s, that was changing from balancing the needs of parents to the best interest standard. Again, the best interests of children. Now, of course, you want them to be with their own family and parents. That's why it's the goal. But safety and well-being was the key as well. So how did this all happen? Well, in 2000, there was a national concern that children were kind of floundering in foster care for their entire childhoods or lengthy periods of childhood. And even the question, where do kids go after they leave foster care? What home do they go to? Where do they go on holidays? Well, our former Chief Justice, Kathleen Blatz, had heard about collaborations in other states that were going to make a model court, get this process going. And some states would have one county or maybe two that would do this. And she decided that our entire state should be a model court instead of just one. And Olmsted County, luckily, was in that first project back in 2000 when there were, I don't remember the number of counties now, but we went in waves, if you will. The first group of counties to really look into this, to have the team together and working with Olmsted Social Services. The key again was this upfront planning, looking to the beginning of a case for alternative placements if kids couldn't meet those needs. And if they could not, filing a termination of parental rights or maybe transferring custody to a relative. But the idea was termination so that these children would have permanency and some hope for them. So I get to my last one, and that's the happiest hearing you'll ever be at, is the adoption hearing, whether kids came through social services and termination of parental rights or a foreign adoption or, whatever kind of adoption. It's a thrilling day. Everybody is so happy. Grandmas, grandpas, aunts and uncles, everybody are there. So those are those hopeful moments for when kids come into the court system. So while the court system certainly for juveniles is to look to their unique characteristics, both the criminal side, delinquency, and the civil side really wants to look at best interests of kids. Thinking about public safety, of course, but the rehabilitation and best interests. So I know that's a lot, but hope we got through it there. And Zoom is a little hard here. So if anyone has questions, or happy to hear them, or comments, or those that have been in, I kind of look at Jane or Karen, you know, they know the system. And
Hi,
others, I just can't see everybody.
yeah, thanks, Judge Jacobson, for presenting that. I was taking notes. My background is in healthcare, so
Oh,
I was
good.
mentally taking notes.
Okay.
We're
And if
gonna
you need more detail, really online, there's a lot of information on the judicial branch website, you know, help topics, even on the child protection cases, there's a video, and I laugh about it because my son, who's now 30, is in the video, and he was in 3rd grade, you know, when we made that video, and it's still up. So, you know, there's a lot of information. Oh, and Julie Duff, I see her too. Okay, corrections. She can fill us in.
And I think Karen McLaughlin has her hand up.
Oh, I bet. Okay.
I do. I actually just had one little thing to add, of course,
Oh, good.
with your permission.
Yes.
You had mentioned with the child protection that
Yes.
children under the age of 10 would go through the child protection process if
Yes.
they committed some sort
Yeah.
of delinquent act. That's really the cutoff between the child protection and the delinquency court is age 10. And the reason I bring it up is I always, when I was doing this work, really recoiled when I saw those news
Mhm.
reports or heard about them of arresting kids under the age
Oh,
of 10.
yeah. Yeah.
That doesn't happen in Minnesota, so you can be assured of that. You see these things in other states that just alarmed me every time I saw them. But as a prosecutor, I always struggled with that younger age of, the question is, where Judge Jacobson talked about the right to counsel, they also have to be able to participate with counsel. And at that younger age, I always, I kind of watch them in court, like, do they understand what's going on? Can they participate with their public defender? 10 was pretty rough when we did have to, it was very rare that we'd have a 10-year-old charged with something, but 11 and 12, they were committing some crimes and they understood what was going on. I did have a couple 11-year-olds that had committed some pretty bad behavior, usually with older siblings was a problem. So we would bring them into court and charge them. But then the benefit of juvenile court is then you can decide at sentencing how to address the fact that they're only 11. That's
Right.
one of the advantages and differences between adult and juvenile court, is that we address their age based on how old they are and what makes sense, and, like the judge said, best interest of the child, and how to rehabilitate. 11-year-old is very different from a 17-year-old. So that's the input from that. And then I did want to mention, I saw Mary Jones's question about mental illness in the juvenile court. I can answer that, or if the judge wants to talk
No,
about
go
that.
ahead, Karen, because you had more recent experience. I mean, so.
Yeah. So Mary's question was about if a young person is suffering from, I would take it a severe mental illness, what happens to them in juvenile court? And it's a very difficult part of that process. That I remember one case where I read a police report where a kid clearly had a psychotic break. He did not know what he was doing. He did not know what happened. His family reported the same thing, and he was either 16 or 17. So that's the time when I knew that schizophrenia could be coming through, that kind of thing. And we ended up not charging him because I knew he wasn't responsible for his actions. That's the kind of the standard we have to look at when somebody's competent for court. So there are processes to determine if someone's competent if we have questions about it. That one was pretty clear to me that he wasn't. But then that was a gap in the system, because when we look at what to do with somebody with a severe mental illness like that, can they be committed to an institution? And when they're 16 or 17, the county and the state generally don't do that. So I actually had to really work with my coworker in social services to say, this kid needs to go through that system. I know you don't do it very often. It looks very different, but this young person does. So he, I believe, went from the detention center right to a commitment, and they did commit him as a 16 or 17-year-old in that more adult mental health system, but it got him the services that he needed, and that was what was critical. So that's where we could be a little bit more creative, but it's all those systems working together to do what's best for the kids, and it was good to be part of that.
Yeah. That again, though, is where the county attorney is the pivotal person of knowing where you're heading with that kind of case. I would say that would be the mental health issues early on we don't always recognize. until later on.
Right. And I would just give a little bit of plug for being in that role, the 15, 16 years that I was, that's what I really liked about that role is I loved working with Judge Jacobson in the courts, but the prosecutor has the discretion to bring those cases or decide what to do. And it's a very important and critical role of that process because the prosecutor is the first one to look at the case and make some of those important decisions that then determine what's going to happen next in the case, both with the prosecutor and the child protection cases.
I think I'd give a little shout out. I see Julie Duff there, but court services, really those evaluations, especially those early ones when we don't really know what's going on. Do we need more of a mental health evaluation or where to go? That was really helpful to me. Because I mean, we're reading the report, the family comes in, I know nothing about them. And unless you've seen them before, or they've been in the system before, but court services plays a real pivotal role in those as well. Oh, there's Julie right there.
Yeah, and she had a comment in the chat.
I missed that. Here we go.
She said that they fill out a form, I think, about mental illness
Okay.
at the beginning. And so we'll continue with questions and just remind people you can put your questions in the chat and then I will go ahead and ask them. And if Julie, if you wanted to speak to the mental health part for it, just raise your hand and we can call on you. And I'll move on to one of the first questions so we can come back to the mental health. So there's a question, is there any legal training or professional training that is required as for a judge? And especially, is there special training for the youth court? And one other question I have to tie into that, at the district level, do judges specialize like in youth court or in any of the like the delinquency or delinquent traffic victim or child protection? And I bet you all put your hand up to do the adoptions is my guess, but I'll turn that over to you.
Well, in terms of training and specialization, I'd have to say there's a lot of continuing legal education, and you probably pick your own interests, if you will. Every district probably makes decisions about specialization or not. When we started even before the CJI kinds of things, Judge Birnbaum and I would switch off with juvenile, and Judge Ring before that, we had decided in Olmsted County that, I don't want to say it's a luxury, but it's important that one judge hear kids coming through the system so they know what to expect. You get to know those families and cases, especially with child protection, because those hearings are more frequent. So the training continues, but when you first go in there, probably not right away, but there's a new judge, they go through some initial training. I can't remember what it's called. We called it baby judge school, but I don't know what others called it. But specialization, that's kind of district by district or what people want to do. So I'm thinking back, well, Judge Lund I'm not sure how long he's done juvenile court again. So I think it helps to have one judge in there and continue with that training and looking for continuing education.
And that's that. The other question I have is the right to counsel, and I think there's a guardian ad litem I wrote down somewhere. The goal is to have them follow through the whole process. Does the judge, the court system do analysis on that to see if that happens? Because that seems really important for youth to have somebody that's consistent.
I think in the juvenile area, at least when I was there was mainly one public defender that really followed through with kids and met with them regularly. The guardian process, I suppose, I mean, they were run by the state, but they have to supply their reports to the court in a timely way. So you read what they've done, who they've interviewed, how they made their conclusions. They have to document that. I can't say that I personally had issues with that.
Okay, good. That's good to hear because that seems important for you. Another question we have is, what is the process and what are the options of a juvenile seeking the status of emancipated minor And have you had any experience with that?
You know, it might exist out in a statute, but no, no, there isn't.
Okay.
People, it's kind of like either the child wants to get away from the parents, or the parents would like to come in and file for a termination of parental rights, and you can't do it unless there's an adoption coming up. So no, it's kind of a fake thing out there from my view. I don't know if Karen or others have had experience.
And so I'll go, go on to the next question. This is kind of a specific question, but I'll throw it out there. How often is a stay of adjudication used in juvenile court? Will a stay of adjudication show up on a background check, or if it is a felony charge of a juvenile, will a stay of adjudication for a felony need to be admitted on a job application?
Well, I'm going to let maybe Karen answer that. Stays of adjudication were used quite frequently, I think, depending on, you know, pre-trial, maybe somebody went to treatment, they continued the matter. And in terms of what they have to report, I will maybe ask court services if they can jump in, or Karen.
Yep, I think Julie Duff has her hand up.
Yeah, good. Yeah, they deal with it more than I would.
She's unmuted.
Oh,
Hi.
hey.
Oh,
Yeah, I'm a probation officer. I've been a juvenile probation officer for, gosh, 23 years now. So I have an answer to that one. And pretty much every child that comes through the juvenile delinquency system now is getting a stay of adjudication. So we're using that to get services to the high needs kids and really try to not have the collateral consequences of being adjudicated impact the kids. And we get up to a year to for the kid to kind of lower their risk and get things back on track. And most of the kids do get the benefit of the stay of adjudication. In fact, if we have a child that's really struggling and maybe got another charge, sometimes the court is allowing that first case to expire and then give us another 6 months with that new case to really just keep working with the kid and the family to help them out, to get them where they need to be without having adjudication. So right now, the juvenile court in Olmsted County is really, really child focused about not having a record with these kids. So it's a good thing.
good.
And I can add a little bit to that discussion that one of the things people have to be careful of is there's a lot of legal terms and legal wording. So for example, if somebody had some sort of, you know, it might be a specialized application for the military, something like that. It might not just be that stay of adjudication that's the sentence, but there could be questions like, have you ever been arrested? Have you ever been charged? Have you had police contact? Those are different questions than the stay of adjudication. So I always told people, you know, be very, very careful and read the documents very carefully about what questions they're asking, because it might not be asking about the end of the case. It might be asking about the beginning of something. So that's important for people to look at. The other piece of things, I know that the question kind of related up to background checks. Years ago, probably 10 years ago, maybe 8 years ago, cases, even if it was pending a stay of adjudication, even a stay of adjudication, they would still be viewable in the court system. After I left the county, I know that those things have really changed, and, you know, cases that haven't been resolved yet aren't available. And stays of adjudication have a very different look in the public access court system, which is where the background checks are done, compared to how it used to be. They're much more locked down and confidential than, you know, 8-10 years ago. The other piece of things is you always wonder how much of that data is out there on the internet if somebody has collected it in some form, that it could be accessible to people. And that's the risk, is that if you say, you know, no, I've never had anything, and somebody finds something, you know, it might be, you know, 8 years old now or something like that. You have to be cautious to make sure that you're not misleading an employer.
Okay, thank you. And thanks for Julie and Karen for jumping in.
Very helpful, yeah.
Another question we have, is there any specific training needed to represent specifically children? Like for the public defenders or an attorney that represents?
Well, I think they have, training and an interest in the area, so certainly that interest, or once they become a public defender, somebody can hire their own attorney as well. They don't have to accept a public defender if their parents have an attorney that's interested. But yeah, I don't know if it's specialized right off the bat, but certainly there's training. I think just like anything, you find attorneys in all aspects that you think really are superb, and some are just okay. And you hope for the best in your county.
Yeah. Idra is asking this question, and I need this defined too. What can you explain what a stay of adjudication is?
I'll let Karen do that.
Oh, okay. What a stay of adjudication means is that when a case is at the end of the case, so it's either someone has pled guilty to some charge or is found guilty by the judge in juvenile court, then they go to what's called the sentencing or the disposition phase. And that's one of the neat things about juvenile court too, is there's a variety of things that can be done at the disposition stage that, like Julie was talking about, are beneficial to the young person, to give probation or social services the ability to work with a young person, but not hamper them with something that's going to be on their permanent record as they go into adulthood and start looking for jobs. So a stay of adjudication, so the word adjudication is sort of like conviction in adult court, but the stay of adjudication means the court does not enter that adjudication unless something happens in the future, like a probation violation or a new charge, like Julie was talking about. So it's a mechanism for the court and the attorneys to use to have some authority over the young person, but not label them as a delinquent or label them as someone that's convicted of a crime, unless there's future concerns about their behavior that leads the court to change that. It's called a disposition. So it's something that actually happens in adult court more frequently now too, but it's like Julie said, that's very common in juvenile court, really to recognize the fact that young people are not fully developed, their brains aren't fully developed, they make poor choices at times, and the stay of adjudication recognizes some accountability for their conduct, but not the long-term consequences.
Thank you for that. Another question we have, can you speak a little bit about the privacy issues for children in the court system?
Well, under child protection, they used to be, a long time ago, those were all closed hearings. And then somewhere along the line, I don't know if news organizations, metro counties, there were some problems and they thought they should shine a light on those problems, and the court opened those up and they are now open. But a lot of the reports that frankly we talk about at a hearing, those are not accessible to the public, but it is an open hearing in child protection. I rarely saw any extra people there, but that doesn't mean people wouldn't know about it. In terms of juvenile court, it's open with felonies 16 and over, or certification issues. I don't know, when you talk about social media and that kind of thing, what witnesses might have out there, or what happened to them, or doesn't prevent a victim or somebody talking about cases. So I don't know in today's world what that all means in terms of privacy, but the court tries to protect that by the closed hearing, that other people don't come into the hearing other than the participants, the county, the parents. But they're waiting in the hallway. Other people see them. They're at the courthouse. So in terms of that privacy, I guess that's gone.
Yeah, and social media adds a wrinkle, doesn't it?
It adds a wrinkle in just about every area you see in the courtroom. Yes.
Yeah. And Karen has her hand up.
Sure.
We just have to unmute you. There we go.
Sure.
Oh. I think you have there we go. Sorry about
Yes.
that.
Judge Jacobson had talked a little bit about victims' rights in the system. Even if a delinquency case is a closed hearing, the victim still has the right to be there. The victim's parent can be there, a victim advocate can be there. And it's a really good way to follow the process. And again, like if it's not an open hearing, they can still give their victim impact statement and have input into the process.
Okay, thank you. A comment from one of the attendees, a good movie regarding Gideon's and the process he went through is Gideon's Trumpet. So just putting that out there for a movie, sometimes that's a good way to learn something. Another question, and this is a good, we have some good questions. Does our county have a separate holding cell, jail, prison? Well, at the county, it's a jail for juveniles.
Well, they did. I don't know where they go now. Maybe if Julie's still here. They did have the juvenile detention facility, but that was closed. So I'm not sure where they're holding juveniles today.
They usually go to the Dakota County Juvenile Center in Hastings. There's also an option in Lino Lakes, the Anoka County Juvenile Detention Center. Those are the two that are basically used, but juveniles cannot be held within sight or sound of an adult. So that is a law there, but yeah, they don't go to juvenile jail very often since we closed in 2020. It's usually on the heels of a serious felony arrest. There's some good things and bad things about that. I think sometimes kids were going there to our detention center for the wrong reasons. So we've been able to reduce that issue, but yeah, it's a gap in our system at the moment for that one situation where we need a young person either off the street for public safety or maybe just a quick stopgap for their safety until we can get some services in place. It's not the best use of a detention center, but sometimes our detention center was used for that purpose.
And you said that it closed in 2020, is that correct, the local one? Did that have anything to do with COVID? And then to extend that, has COVID affected the youth courts in the last couple of years? And I'll throw that out to the three of you.
I don't know if COVID was directly related to it. I know we were being trained, the probation officers were being trained to fill in at the detention center in case staff went down with COVID. So that was in the process in February and March. And then I think it was a pretty complicated decision, and I probably wouldn't give it justice to speak to it, but it came from the board, the county board, and it was an expensive thing to run. And it was closed pretty quickly. And we've tried to kind of plug the hole a little bit, but yeah, it wasn't directly related to COVID, but I think a lot of decisions were happening pretty quickly at that time.
Can I just ask, Julie, what mental health facilities are being used mostly by the county now? I know as a judge, you relied on social services, court services to know where the bed space was, what was the better program for kids.
Locally?
Sure. Or maybe they're not as local, yeah.
Well, we did have a day treatment program called Youth Night Campus, and that's no longer available. We do have the Southeast Minnesota Crisis Center out there by where the detention center was, and they'll take juveniles in at a crisis moment to kind of get some services in place, but that's very voluntary. It's not a locked facility. There's always an evaluation at St. Mary's. Lots of agencies are providing some day treatment for juveniles, but it's not on an emergency basis. There's a big process. There's a diagnostic assessment that's needed. There's several steps and several appointments before a juvenile can ever get into the treatment program. And that's sometimes difficult, you know, not every kid is super anxious to join a psychiatric group with a bunch of other kids. So when they're willing to do it, or when we got them maybe willing to go, it's a short time span, and then they're like, I'm not going. And so having mental health professionals in the school has been a lifesaver. I mean, when those kids are at school and they're having a meltdown or something happened at home, or they're just feeling like talking, and they can walk down the hall and walk into a therapist from Zumbro Valley that's actually sitting in an office in the high school, that's invaluable. So when I saw that that was maybe something that the school board was considering taking a look at, I fired right up, because I was like, no, you can't get rid of those. I mean, it's a beautiful thing having the mental health professionals in the school. And I could talk forever, so I'm gonna be quiet now.
Great. No, it's very helpful. Well, you can see how the court really does rely. We don't bring our own information, really. Everybody brings the information to the court. So when court services knows the child, met the family, writes a report, everybody gets a copy of that and agrees or disagrees with it and makes comments to the court so that you can make a disposition or a meaningful decision. What's really hard is if you have, even in adult court, people come in, you know nothing, and there's no way to get that information. So, and knowing what facilities might meet those kids' needs is really something social services, the guardian, court services brings to the court to make decisions.
Here's another question. Do judges interact with youth outside of the courtroom?
No. You mean like out in the hallway or talking to kids? I wonder what that.
Yeah, I'm not sure.
No, yeah, I mean, you can't just talk with kids separately. I mean, it'd be like talking to a party, or, you know, you need to be fair to everybody. And if you talk to somebody alone, you really should be talking to everybody. You could interview a child separately, sometimes in family court, but that's on the record and fairly rare. In terms of interacting with kids in the community, sure, there may be judges that volunteer with different programs, or maybe just kids in general. But I don't think we have a program like Cops with Kids or Go Shopping at Christmas, or, you know, anything. I'm not aware of it anyway. Nice programs, but I don't have one.
Right. Are there any other ways in which youth interact with the court system?
I couldn't think of any, but if anyone else can think of one. Well, juvenile traffic, I kind of left that out, but, you know, you could have a traffic ticket and pay that, or come to court. If you have a DWI as a child, you go to it. Frankly, you go to adult court for that and have an attorney. So I guess traffic would be one.
And then there's another question, and you may have answered this, but how did juvenile court come about? And did it come about in different times in different parts of the states or states? And then
that's a good question. I don't know that I know the answer to that by itself. You know, I suppose the juvenile was in the old county court before, you know, the courts unified, I think in the late 70s, where district court was one court. Otherwise it used to be county court and district court, and the district court had the criminal cases. I think county court always had juvenile, family, but how it became a separate court or separate statutes, I don't know the answer to that.
Okay. Are there examples of things that have happened in Olmsted County that show efforts to protect the rights of youth? Are there challenges in this area?
Well, I think Karen mentioned, yeah, go ahead.
And also, while you're answering that, I'll combine another one. Okay. What are the differences between rights of youth versus the rights of adults? And you may have mentioned it in your talk, but that might be good to go over again too.
Okay. Well, that first one, well, the rights of adults and the rights of kids, I mean, really, that's pretty much the same in terms of the right to counsel. In those delinquency matters, serious felonies, the right to counsel attaches immediately when you come into court, that you would have a public defender. You don't wait, you'll have that attorney. In the adult court, they have a defendant has the right to apply for a public defender, and if qualified, would be appointed that attorney. The attorney would be throughout those proceedings. Even at sentencing, the way an adult has the right of elocution before, you know, let's say they've been convicted of some serious matter, maybe they're even on their way to prison, or maybe not. but they have the right to make a statement to the court. It's the same in juvenile court. That juvenile has a right to make a statement to the court before sentencing. The juvenile, I think some of the challenges, one of them that Karen mentioned that I hadn't thought of immediately, but I think it's realistic, is whether kids, are they able to communicate what they need with their attorney? You know, a guardian may listen to a kid and say, you know, that's not in their best interest what they're thinking. The attorney can do some of that, but they really have to advocate for what that child wants. So just like the adult, if somebody wants something or that's their position they're taking, that's what the attorney must advocate for. In juvenile, it's a little bit nuanced, I guess I'd say. But I'd be concerned at times of what Karen talked about, with some kids not having the capacity to really meaningfully participate.
And sometimes the mental health issues are developing. And so
correct.
Yeah.
Correct. Or just immaturity. You know, yeah, they may have seen court and know what's going on, but do they really know when you plead guilty or admit what you did, that the next step is the court can sentence you and you may have to go to counseling or do community work service or pay a fine, those kinds of things. Do they really know and grasp what's going on?
Yeah. And Karen, you have your hand up too, I think.
Yeah, I do. I think what Judge Jacobson's talking about is that every one of us has the same constitutional rights as a basis. They apply to juveniles, they apply to adults, they apply to everyone. But where I saw that play out a little bit differently for adults and juveniles is when you looked at an issue like if someone had given a statement to an officer, whether that should be admitted into court or suppressed. And it kind of comes down to different factors and the circumstances. But and then people hear about, you know, whether somebody has had their Miranda rights read to them or not. I always advise the officers to be cautious about that and, you know, read the Miranda rights. If they give a statement or not, it's not as important as making sure that they're aware that they have those rights. Also notifying parents that some officers were, you know, kind of didn't want to do that and said, you know, you have to do that. Because there's case law that talks about that. But I think the difference comes down to, you know, does a young person know that they've been arrested and are in custody and are giving a statement that's going to potentially implicate them in a crime? An adult very clearly knows that. I mean, they've been around the block enough times to know that that's a situation. A young person might not know that. So, you know, I kind of looked at it, you know, under 14, they may not understand as much, but maybe 14 or older, 16 or older, they have a better understanding of the system. So it also depends on if they've had prior experience with the system, prior experience being interviewed, but it was always something that I took a very close look at when challenges were made to whether they were making a statement that was in violation of their constitutional rights or not.
Okay, I think we have two more questions.
Okay.
And the question, let's see, I lose them. When deciding what is best for a child, whose opinions or advocacy are taken into account?
Well, I think that's why everybody has a right to participate so that they can present what they think would be best and evaluating that. I suppose in some ways it's a little subjective knowing what you know about kids or what you know about that specific child. But the social worker at a hearing, court services at a hearing, parents have a right, and parents may not agree. I mean, certainly there's a lot of families where parents aren't together and they may have different opinions about what's right. So you have to listen to all that and frankly hope you make the right decision. That's, you hope.
So I lied. There's actually another good question that came up, and it's about where did I lost it? It's about children or families that are not English speakers or English as a second language. What protections, what help, what is available to them?
Well, the entire court system has the interpreter services. So right away, finding that out. Social services uses interpreters. Law enforcement uses interpreters. So that's really the protection there is, you know, finding out what language. I don't know how many languages. It's an incredible number. I think right now on staff, though, we always had someone at the courthouse when I was at English and Spanish and Somali, but now with Zoom in particular, any language at any hearing, and we ask, or the attorney tells us if they feel they need an interpreter, we appoint one.
Okay, thank you.
Yeah.
I think that's true with healthcare too, that, you know.
I think so. Yeah. Yeah. I think people are pretty responsive to that. And sometimes people speak quite a bit of English, but you know, it's uncomfortable. This way they know somebody's there to help them along. I mean, before we had so many other languages, I mean, gosh, in 1980, I don't know that we had a need for much interpreting. But once in a while you'd have someone, well, they would come with their mother, or they would come with their neighbor. And if it was, you know, nothing very serious, that's how you dealt with it. But over time, that's really been formalized to protect everybody.
That's good, that's good.
Yeah, it is.
Last question, and then we'll go to closing. Has there been any long-term assessment of court procedures for juveniles? And my question added to that is, who would actually do that? If would do that assessment, if there would be one?
Oh, it's probably some academic that's written some kind of report, psychologist, psychiatrist. Those are the kind of people that, you know, do bring us things at continuing legal education, or, you know, learning about what might change. But I don't know of any, I'm not aware of a specific evaluation in Olmsted County. I don't know. I don't
But there's
know.
not like a formalized assessment that, you know, okay.
I don't know of one, but.
Okay.
No.
Well, thank you. I learned a lot this evening. I have a lot to learn. I don't have a great context of the system, but I have a much better one now.
Good, good, good.
And so thank you for the information, and thank you for talking about youth and courts. And I would like to, and there's never enough time to get to all the questions, but I think we got to most of them this evening.
Good.
And I want to thank you, Judge Deborah Jacobson, for taking the time this evening to explain some of this to us and give us information and answer all the questions. And Idra, I want to turn it over to you for final comments, and then to Judge Jacobson for any final comments that she has. And so Idra, go ahead. There we go.
Thank you. I really enjoyed it. I hope everybody found it as informative as I did. Thank you.
Thank you.
Great. Wow. Thank you. And thank you for thinking of the topic. I mean, I think that's I still think that's amazing. I mean, 9th and 10th grade, I liked history in that, but I don't know if I would have ever gone on to try an internship and put something together. So you should really be commended, and the league and April helping you or mentoring you, that's been great. I'd like to say that I'm really grateful that there were others here in the system that could chime in with information and how helpful that is. I really do love a panel. So that's kind of a nice thing. I think Olmsted County is in pretty good shape, frankly. There's always been a lot of wonderful social services, court services, all those team kind of building to help everybody. And then when there's one judge in juvenile, you kind of get to know the people. And I think that's really helpful for the community as well. So
thank you. And thank you, Judge Jacobson. Thank you, Idra. And I want to just let people know about upcoming events. City of Rochester's response to climate change. We will have a forum like this on Thursday, March 14th. Look at our website for links to that. And also our annual spring membership meeting and brunch will be Saturday, April 23rd. We are crossing our fingers and planning it in person. And we'll see, we may have to pivot to virtual, but right now we have it, it's going to be a brunch. And it's going to be April 23rd at 10 a.m. So, and we will be having a speaker, Virginia Wright Peterson, who talks about women's roles in Rochester. And I know she's written several books, and one of them have been about the women's roles in the war effort back at home, here at home, and also overseas during World War II, I believe. And so she'll be our speaker because she's writing a new book, will be out. And we also have our League of Women Voters Minnesota Council will be Saturday, April 23rd. That will be virtual. We thank you for coming, and thank you for your time. Idra, for setting this up. This was lovely. And thank you, Judge Jacobson. And also thank you, Karen McLaughlin and Julie, for your input. You made this, the information very helpful. Thank you.
But I do see a guardian there, and I wish I'd seen that. I would have called on her too. And I see another attorney there, Jen Nguyen, and my friend Betty from our book club. I wish I'd looked closer. So, bye.
Thank you. Good night and have a good night.
Thank you. Thank you.